All right, we're right to go. Hansard, all good? Thank you. Well, the time now being 2 o'clock, I welcome Mr Lindeberg, representing the Whistleblowers Action Group, who have made a submission here. I also note that Mr Lindeberg has made a submission in his private capacity as well, which we have received. Mr Lindeberg, we have set aside something of the order of about 15 minutes for each of you in each of your two roles, if I can put it that way to you, to make your opening statement, and for the committee, if they do have any questions in relation to your material, to ask you for those questions. As you know, we're inquiring into Section 329, and as with the Bar Association and with the member for Coomera, we'd ask that you stay relevant to the matters currently under discussion by the committee. And I welcome you to make an opening statement, and then we'll move to questions, if any, from the committee members. Thank you, Mr Lindeberg.
Thank you, Mr Chair. Mr Chair, Triple C members, on behalf of Whistleblowers Action Group and myself, I thank you for this opportunity to speak to this important review of Section 329 of the Crime and Corruption Act today. Evidence set out in our public submissions, I know, is known to relevant bodies, and I'm sure that you've all read it very carefully. Mr Chairman, can I just start by saying this? Blowing the whistle is a very, very dangerous activity. Voltaire gave us his dire warning when he said, "It's dangerous to be right when government is wrong." Whistleblowers rely on what this legislation says and purports to mean. We risk virtually everything on that premise. We trust and expect the CCC, the PCCC and the Parliamentary Commissioner to perform their respective watchdog roles honestly and impartially in accordance with what the law plainly says and means in English. Our submissions, however, demonstrate legitimate, real and present concerns which we think are too significant to ignore, hence our being here today. Parliament has or may use in Section 329 and its related Section 15, which defines corrupt conduct, as can be enlivened under Section 329 4C and H, operational words like impartiality, honest conduct, improper conduct, corrupt conduct, abuse of public office, as they apply to the CCC, but the CCC, PCCC and Parliamentary Commissioner can then reduce their English meaning to absolutely anything and nothing, and do so with impunity, we believe. I can say this with authority by your decisions, which is found in my submission. You have now set the standard of conduct which is acceptable in public office in Queensland. This is because the CCC's conduct is the exemplar par excellence for others to follow. You have endorsed it. It is a standard, however, which I and Whistleblowers Action Group forthrightly reject, and for very sound reasons. Mr Chairman, the CCC cannot, in my view, ethically and morally conduct this review without the assembled Parliament, the people of Queensland, the media and would-be whistleblowers hearing the truth about what's really been going on behind the scenes relevant to this section in this most important area. Your so-called standard, acceptable standard for CCC officials, comes from these facts. The CCC Chair, Dr Levy, and the board decreed in March 2015 in writing to me that they would appoint a retired interstate Supreme Court judge to review the allegations of the Hein Affair papers. They then did the exact opposite. That is, the CCC secretly appointed a recently retired Supreme Court Justice, the late John Muir, while the CCC knowingly deceived me into believing it was still acting as promised and kept this deception up through the entire 12-week period of the review. On my values and experience, and on the plain reading of English under Section 329 and 15, I say that when this happened, I was knowingly, seriously and egregiously deceived for improper purposes. I saw this systemic cover-up continuing on. I was deeply shocked at the betrayal when the truth was finally revealed. Now, I complained about this egregious violation of public trust to you under Section 329 of the Crime and Corruption Act. Now, for the record, the new chair...
Can I just ask you to wait one moment, Mr. Lindenberg, and I'm reluctant to interrupt you, but sorry. Sorry, take it. Yeah. And that's current, isn't it? Yeah. So, as I'm sure you'll appreciate, where there are current matters on foot before this committee, as a result of complaints that are being investigated through the PCCC, those matters can't be referred to under Standing Order 211 in relation to what is or may be occurring under the current PCCC and what we're currently doing. So, reference by you to matters that are currently the subject of investigation by the PCCC is a breach of Standing Order 211, and I can't allow you to continue to do that in this hearing here. As you recall from the beginning, when I opened up the public hearing and made comments about the hearing occurring under the standing orders of the Parliament. So can I ask you to constrain your submission and your evidence to the committee to the subject matter of Section 329, which is what this hearing is about. So this is not a re-litigation of other matters or a fresh hearing of those matters. So can I ask you to maintain compliance with the standing orders and with the direction of the committee in order to be able to do that?
Mr. Chairman, I am here to certainly comply with what you say.
Thank you.
But also, what you haven't said in that is what I'm talking about, according to your committee, is functus officio.
Well,
and in doing so, you have made a judgment in relation to 329, which is acceptable. And I'm saying that's not correct, and we need to look at that.
Well, Mr. Lindenberg, let me be blunt to you. The committee is here and constituted to inquire into the matters of reference under the terms of reference for the investigation into Section 329. Mm-hmm. Previous decisions that the committee has made are in fact valid decisions of a properly constituted committee, whether made up of these members or others. It is not functus officio, and simply using a little bit of Latin is not going to make it so. So can I bring you back to the point? It's not a question for argument. It's a question of you being able to make a submission here, and we are very happy to have you here to make those submissions, but they must be pertinent and relevant to the matter under investigation by the committee, and they must not contravene the standing orders of the Parliament in relation to current investigations. So can I bring you back to the subject matter and ask that your submission continue to comply? Within the requirements of the standing orders, as I've said, you are free in front of this committee of the Parliament to be able to make submissions regarding the matters regarding the definition of improper conduct under Section 329.
Yes.
Over to you.
Well, let me respond in this way. I'm trying to address the compass of what's it called improper conduct under Section 329. I understand when I get a letter, or anyone gets a letter, put it that way, gets a letter from the CCC undertaking to do something upon its consideration of the allegation before it, that it warrants the appointment of an interstate retired Supreme Court judge. And then you find out later that they have done exactly the opposite. Now, where does that leave us as whistleblowers?
Let me just halt you again, because you're referring to a matter again which has been a decision of the committee, which is subject to Standing Order 211. If you are able to frame your discussion in relation to how you think the definition of improper conduct under section 329 might be better worded or cover the issues that are of concern to you without referring to matters that have been subject to committee inquiry and have completed, because those completed matters are still subject to Standing Order 211 or any other matter, then we're very happy to hear what you have to say. But by referencing actual matters, you are then transgressing on Standing Order 211. So if I can perhaps give you that guidance in terms of how you might present your position to the committee.
Well, I'll put it perhaps as a wording in my submission, where I said if a whistleblower, without saying it to me,
Yep.
should approach the CCC on the basis of an allegation, and the CCC understands that the allegations have substance and require the appointment of an interstate judge, and the whistleblower gets it in writing, and then he or she finds out later that that undertaking has been breached in a material way, then I believe that a whistleblower is entitled to believe that that is not unbecoming conduct, but it is official misconduct, or reaches a view of being disgraceful, if you like. But certainly, in my view, it also triggers section 329C and H, I think I'm saying correctly.
So if I can say to you then, in that sense, what you're saying to us here today is that from the perspective that you look at it, the current definitions are not wide enough to cover some circumstances that may pertain to an investigation or actions by members of the Commission.
With great respect, you have put a gag on me, and I'm trying to respect it.
Well,
what I'm saying to you is when a whistleblower decides to blow the whistle, by looking at the words of legislation, he puts trust in what those words mean. And he expects that when one sits with a CCC head and you get something in writing under the letterhead which says it will do something, as an ordinary citizen you are entitled to expect that what they promise you to do, they will do. Moreover, if they let you believe that they're doing what they promise, but in fact they're doing something else, and you're cooperating on those bases, I suggest that's not proper conduct.
So,
and if the law was applied properly, I'm suggesting,
sure,
you would so find.
Well, again, I think you're straying back into the area, the subject of a matter that has already been resolved, and which is subject to Standing Order 211. You're not dealing with the issue that this meeting or this public hearing is to deal with, which is to do with the operation of section 329 in that sense. Now, I understand you have an issue in relation to another matter. That matter has been dealt with by a prior committee, and the results of that are still subject to Standing Order 211.
But what I'm saying, look, I appreciate that, Mr.
So here
Chairman,
today we're looking at what the operation of section 329 and how it operates.
understand,
So if you can give us your concerns in relation to that.
Our concern is, as I said right at the beginning, you can put all the words you like in the Act. But then when a case comes forward and the words that we understand to be so are not so interpreted, well, where do you go? I'm saying to you that if a whistleblower gets a letter from the head of the CCC to do something which they have decided needed to be done, and then they do the exact opposite, and nothing happens as a consequence of that, where do you go? Why would you ever blow the whistle? And on some, I mean, in many ways, because I am gagged.
Well, let me just deal with that. You've said that twice now, and I let it go the first time. But I just want to be clear with you. I'm not gagging you in terms or restraining you in terms of the submission for the purpose for which this inquiry is set. You have and have exercised other rights in relation to matters you have referred to here, and you have received responses from the predecessor of this committee in respect to the exercise by you of those rights. Now, I understand in respect to that, and we can't talk about it because it is covered by the standing orders, that there are other issues that you have from that. But I want to be clear.
Yes.
I'm not gagging you from making submissions that are appropriate to Section 329. And I am trying to give you every opportunity to make a submission without breaching the standing orders. And perhaps one way to do that might be if you could perhaps expand on why you believe the term disgraceful and improper conduct is insufficiently defined. And that would certainly fit within what this committee is here to listen to and to investigate.
Well, you see, I mean, I listened to Mr McSporran, who said, you know, we all generally know what the word disgraceful means. We're educated people, you understand. When a whistleblower sees something, he doesn't necessarily go and talk to a QC to find out whether or not this is a breach of the law or whatever. They often act instinctively in terms of what they understand the right to be. Now, I mean, one's caught a little bit in a cleft stick here, because I hear what you're saying, Mr Chair, about what does the word disgraceful mean. Well, you know, and then when I go to the next thing and say that in point of fact, my understanding of the word disgrace or dishonesty is something which I have experienced at the Triple C, but I can't talk about it. Now, because of standing order, and I want to respect standing orders.
No. Let me say to you, if you think there's a shortcoming in the words disgraceful and improper
Well,
conduct,
arguably,
then today it is, but you just can't refer to that
arguably,
matter.
no, but arguably, there's not. It's a question that when they are applied, you can't trust that they will be applied. I mean, as I say, if I went to see the if a whistleblower went to see the Triple C,
Yes.
I mean, it's almost reaching absurd levels, in the sense that to understand whistleblower, I don't know whether any of you people have ever blown the whistle, but of course, in some senses, you try to seek guidance and so forth. But there's an instinctive aspect of it to understand that when something is done, it's wrong, and then your morality or whatever it is tells you to do something.
Perhaps I can assist you a bit more so that you don't feel so constrained. You can discuss your dealings with the Triple C other than the subject matter of your complaint with the Triple C. Does that...
Well, I suppose what I don't look... I greatly respect the institution of Parliament and your committees. Don't let anybody doubt that. But and this is the People's House. When you draft legislation, it's best if it's not necessarily drafted on theoretical things. It's drafted on a case study. Previously here, when you've come in and talked about the Fitzgerald Amendment to this particular Act, you're talking about an incident when people at the Triple C inadvertently or mistakenly started to shred Fitzgerald's records, which generated an inquiry by the PCCC and so forth. Now, you've used that example. I have an example, but you've been posing Section 221 on me, which I suggest is highly, highly relevant, because on the face of it, when I sit here and watch your discussions, everything seems to be running quite smoothly. And I'm saying to you, it is not. And what I'm trying to do is to put the example of it okay, you've heard what I've said, now I qualify and say, if a whistleblower, you can make your connections if you like. If a whistleblower sat across the table, put the evidence to them, and they understood it, they examined it, and they said, yes, Mr. Whistleblower, we will appoint a retired interstate judge, because they knew the nature of the allegations warranted that, and they put it in writing to you. Why ought not the whistleblower be able to have confidence that what they're telling you is the truth? And if it turns out they're not, what then if the whistleblower says, oh, well, look, it was unbecoming, naughty, should have told you? As if to suggest that had he told the whistleblower would have accepted. Plainly, the whistleblower would not have accepted, because the whistleblower knew what the law and what the agreement was. Now, what I don't want to see happen, because I don't know whether many people here necessarily know my history, some do. But I want to protect future whistleblowers because they put faith in these words. And these words have found out to be empty when it comes to a case which I can't talk about. That's the concern. That's the concern of whistleblowers because we want to protect the integrity of whistleblowers, the future prospects of whistleblowing.
Indeed. So if that is the case, then in terms of the submission that you wish to make, then what is, to go back to my earlier question, can you expand on why you believe the terms disgraceful and improper conduct are insufficiently defined, which is,
well,
in that sense, the nub of the action group's submission?
Well, it may. Well, one might say, well,
I put aside the reason why your history in that respect, and then say, if you can say, well, here is an ongoing reason why legislatively this change would be worthwhile making, and to expand on that.
Well, I heard Mr. McSporran comment say, well, if you start to, like codify words, you can limit them in some cases, right? I'm aware that under the Act, the word unbecoming is a word which is used against a police officer. If a police officer acts in an unbecoming manner, he can be disciplined and indeed lose his job. But it appears that when unbecoming is a word which can be used for other conduct under the Act, and it means nothing. Now, so insofar as the difference between unbecoming and disgraceful, what's the difference? I'm not sure there's any difference. But I'm not sure except to say that under the Act, when it applies to people other than a police officer, it means nothing. I can just say to you that when a whistleblower gets a letter which he takes to believe is true, and it turns out to be true, it is far from unbecoming, because a whistleblower would look at that and say, that's not honest. That's not honest. And I mean, my final, I've got 5 minutes possibly. My final comment in some senses is that a warning to whistleblowers is that all is not what it seems, because as I said from the start, we look at legislation, we think we understand what words like improper conduct mean and so forth. But beware, it may not mean that. And therefore, if you are not certain on that, well then why would you go and risk your whole future on doing that? If a whistleblower can go to the CCC, get this type of undertaking in writing, not just from the chairman but from the board, and is led to believe it's going on when it's not, and nothing is done about it, why would you do it?
Well then, can you suggest then how in that sense, to go back again to that question, how the definition might be changed in order to provide the protection or to provide the reassurance that you say a whistleblower in the future may need? So putting aside your experience,
But you see, I hear what you say, Mr. Chairman. I appreciate what you're saying, but the point being that what one's confronted with is that this particular provision 329 came out of a case in relation to the shredding of the Fitzgerald inquiry documents, which was not a happy thing, right? But I suggest to you, when you know the nature of the case that I can't talk about, it's chalk and cheese. Chalk and cheese. And therefore, I'm not sure that, include the word becoming. But that's a nonsense. That's a nonsense situation, because there are adequate words there, we would suggest to you, which already capture it. The warning is, as I said from the start, that we expect people like the CCC, the PCCC, the Parliamentary Commissioner, to act honestly and impartially. And we say that's in crisis.
Right, well, okay. I think, I've extended on a number of occasions how you think the definition and the operation of Section 329 can be changed or improved to address the concerns that you've identified. And in a number of the submissions that the Whistleblower Action Group has made, which are very similar to your own personal submissions, you've sort of made some recommendations, if I can distill them. Can I just see if I'm right in that, whether this is what you mean? So, what you've said there is basically that if this committee decides the words disgraceful and improper conduct are adequate, then you recommend that a description of what those words mean should be inserted in Schedule 2 of the Act, of the CC Act. So that is in essence what you would see to happen. So how would you expand on that in terms of recommend that a description of what those words mean? Because we go back to the situation where we've had both Commissioner Carmody and the chairman of the commission say quite clearly to this committee, we think the words disgraceful and improper conduct are well understood and are subject to guidance by established case law, including High Court case law.
Do you think if this hypothetical whistleblower got this letter, etc., do you think that the words that are currently in the Act don't capture that?
Well, the question for you is, the question isn't for me. The question and the opportunity for you is to tell us is to tell us, in light of what we've heard from both Commissioner Carmody, who is independent of the who is independent of the Triple C, and holds an independent role, and the chairman of the commission, have both themselves identified the issues around the definition of disgraceful and improper conduct, and identified the High Court guidance, if I can put it that way, around a fairly well-used term. If it's to change or it's to be improved, how do you see this committee making a recommendation in respect to that legislation to improve it?
Well, I mean, I suppose I'd answer that two ways. Because we're a civilised society. We have words in legislation which we think the common person can understand, notwithstanding they have, you don't draft up legislation without going to the parliamentary draft, but nevertheless, they're words which the ordinary person should understand. It's for the ordinary person to understand. And, to go to when I said that in my submission, right, that those words should be further defined, in one sense, you reach a point of view, a position, when I suggest that the issue is so fundamentally clear that a breach of trust occurs, a breach of serious trust occurs, when an undertaking is given by this premier body to do something on the basis of the evidence, and it does the exact opposite in secret. And when it comes to this committee, you see nothing wrong. In that sense, is this a total breakdown where nobody knows what words mean anymore? So, I mean, we can go to say, well, Mr. Chairman, I'd like you within that to also put under the inverted commas, under the definition, the word unbecoming. Arguably, they are all the same. You know what I mean? But there is a sting that the word unbecoming, as it applies to a police officer, can have a sting, but apparently not so to Triple C officers.
But unbecoming isn't used in this section of the legislation, is it? So,
but I'm saying to you, the other thing I'm trying to say, and I'm trying to get through, if you know what I mean, is that it's been applied, and I'm saying the word is inappropriate because it has a higher level to it. But there are many stings that follow from that, and I make the point. Because I hold Parliament to be such a precious thing, that it would be immoral to pass legislation or whatever to allow would-be whistleblowers in the future to believe that these words really mean something. And I don't want that to happen.
All right, thank you. Are there any other members of the... Well, thank you, Mr. Lindeberg, for your submission and for your time here this afternoon and your appearance before the committee. Thank you for taking the time to do that. Thank you.
Thank you.
while you're up, keep going.
Carry on the guard.